Hello, hello.
Hello.
How you doing? Who's that? Where's my
This is
camera?
Mireille. This is
Mireille.
Mireille Barrowman. Hi.
How you doing today?
I'm well, thank you. How are you?
I'm good. I'm trying to start my video here. Hold on.
All right.
Allow.
Is this Alfredo?
That's me. See,
Oh, hi.
finally.
Nice meeting you.
You
Nice
too.
meeting you. I spoke with you many times on the phone.
Okay.
And I took your advice.
There we go.
Yeah,
now you recognize my voice. Good. All right. Sounds good.
Wonderful. And I took your advice. You told me to take the class so you don't call me as often as.
Well, I didn't mean to say that for that reason.
I know.
You gotta take the classes, really. It's
really nice. Yes, exactly. I'm joking.
It's the best thing for you. And look, I still take classes today, believe it or not.
Of course.
I really do.
Of course.
I still do. I mean, you never stop learning. Let me just close the door here. All right.
Of course, exactly.
Yeah. So I guess we're just waiting for John to hop on here and everyone else as well. So
all right.
We'll get that started. All right. Oh, wow. Let's see if I can move this here. Oh, I can do that. Okay, good. I'm just finishing up a couple of more things here before I go home.
So you just start the meeting and then you leave?
No. I'm not the host. So the host is John. So he will be doing the chat.
Okay.
I'm here to support and of course also add any additional inputs that I can provide. So I know Jerry, you know Jerry, right?
Yes, of course.
But Jerry should be online pretty soon as well. So I'm still in the office, so I'm stuck here.
That's great.
Yeah.
I meet all the important people. That's wonderful.
Well, you're in good company here. So
yes, exactly.
So how's your business coming along? What else are you working on now?
Nothing yet, but I'm planning to do some advertising.
Okay.
So to get mostly I get business from my old customers. They want to sell or they want to buy. The kids they want to sell or they want to buy. So all of my customers are, from the past. Right.
So what kind of marketing are you doing?
I'm deciding maybe I do some flyers to that area that I just sold the house.
That's always a good thing to do. Yeah, definitely. So other than sending out mailers, you're going to also possibly want to do stop bys and knock on some doors because you never know, and maybe leave something of value, sort of like maybe a market update regarding the neighborhood, which includes, of course, your sold property. And sort of invite them and say, listen, if you'd like to know what your house is worth, give me a call. I'd be more than glad to, come over and see your home and tell you what your house is actually worth and what you can do to sell it. So, but you've got to do all those little steps. It takes some work to make some real estate. I mean, people forget sometimes that you got to actually work to make money here. Okay. So, yeah.
Exactly. Yes, exactly.
Good.
I'm planning to do that.
Okay.
And the weather is getting nicer and everything is getting much better, easier. Yes.
It is. I was out this weekend. There were 3 open houses for our office. So I was able to go out to a couple of them and they got good turnout. So people are starting to come out. Yeah, definitely.
Yes, exactly. Is Fairfax Realty planning to open any branch in the Frederick area?
Frederick, that's a good question. I can certainly ask Dave about that at another point in time, and I can certainly let you know. So John is here, our host. Welcome, John. Is that a beer? Is that a beer?
No, it's just a big glass.
It looked like a beer for a second there. I thought. All right.
No. Okay.
All right,
So,
there's John.
Hello.
welcome everybody.
Hello.
Hey, John, how you doing today?
Good. Good. So let's see. So why don't we wait maybe just a couple more minutes to see who else joins us.
Sure, of
Okay.
course.
So everybody's week going okay?
Yes.
So far, so good. Yeah.
Good.
All right.
Let's see if I can remember how to do this. Oh, that's right. See, I almost forgot how to do this. Okay. Hi, Rebecca.
Hi, John.
Okay, so we'll get started in a couple minutes. We're just going to see who else joins us because it's only 2 minutes past. And I've just rediscovered how to share my screen so I can pull something up here. Aha.
Are we going to talk about the contract of sales today?
Yes, we're going to
All
talk about the MAR contract. So last time, so this is part 2 for those who were not here last time. So this is part 2 of a 3-part series. Although who knows, maybe we'll have part 4 too. We'll see how it goes. And so last time we talked about paragraphs 1 through 19 of the Maryland Realtors contract. So today we are going to pick it up at paragraph 20. And this series is not, I'm not talking too much about addenda, although I do refer to them. Let's put it that way. So, so for the MAR contract that's here that I'm sharing because I rediscovered how to do that. Let's get down to paragraph 20, which is on page 4. And then once we get done with sort of the core contract of MAR, we're going to take a look at GCAR. So I don't know if we'll get there today or if that's going to be next week. Or not next week, next month, because this has been our sort of our second Wednesday of the month contracts discussion. Boy, this is just going very slow.
Page 4.
Sorry, just pulling through the contract is very slow. I know my computer is being wonky, but it's okay. There we go. Oops. Okay, that'll work. Okay. So. All right, well, we'll go ahead and get started. So like I was saying, so this is sort of our second installment of contracts for our second Wednesday of the month contracts discussion. So when last we left off, we had talked about paragraphs 1 through 19, which talked about, some of the particulars of the property, purchase price, settlement dates, etc., financing. And we talked about paragraph 18, which is slightly above here, which is, the different addenda that may or may not be attached, and any other special discussions. And so paragraph 20 is where we start talking about the earnest money deposit. So the earnest money deposit, as you know, is either held by a broker or the title company. So here, this paragraph is really focused on who it's being held. This paragraph is written as though your broker is holding the deposit. And so if your broker is not holding the deposit, you should also be executing the third-party escrow agreement that all of you should be familiar with, that basically says the parties agree that the title company is holding the money when it was received, etc. And then the title company signs off buyers and sellers. Okay. So here we're talking about the deposit, and says if the deposit is held by the broker as specified in paragraph 7C of the contract, and again, we talked about 7C, but just to refresh your memory, that's the payment terms contract on page 1. And it talks about who's holding the deposit, how much it's going to be. Okay. And as we said back then, as part of it, either an interest-bearing account or a non-interest-bearing account. And as I explained, all the escrow accounts, whether it's your broker or the title company, is going to be a non-interest-bearing account. There are very few reasons why it would be an interest-bearing account. So anyway, so here we're saying that, back to paragraph 20, that the buyer is going to authorize and direct the broker to hold the deposit without negotiation or deposit until the parties have executed and accepted the contract. So upon acceptance, the initial deposit shall be placed into escrow as provided in paragraph 7 in accordance with the requirements of the statute. So if the seller does not execute and accept the contract, the deposit instrument is promptly returned to the buyer. So what they're talking about here, the deposit instrument, that's usually your check, okay? And basically what it's saying is that if your contract has not yet been ratified, and the broker, or as is often the case in sort of reality land of real estate, you, the agent, are probably holding on to somebody's check, okay? And once that you get that ratification, you've got that check in hand, because oftentimes, because I see it when I see the contract presentation, that there's a copy of the check that went with the offer. And so what it's saying here is, hey, agent, you can hold on to that check right up until we're ratified. Then you got to turn that check in, okay? And you either turn the check in to your broker if Fairfax Realty is going to be holding the deposit, or if Realty Title Services, or whatever title company you're working with, hopefully it's Realty Title, you're going to want to turn that check into us, okay? So, but that's what's going on here. And so if the seller does not execute the contract as required, then you are able to simply just hand that check back to your buyer client. That is okay, no problem. Okay, but once we have executed the contract, that check gets deposited into the escrow account, and then it will only be dispersed at settlement. But in the event the contract is terminated or settlement does not occur, The buyer and seller agreed that the deposit will be dispersed by the broker only in accordance with the release of deposit agreement executed by the buyer and seller. In the event that buyer and seller fail to complete the real estate transaction in accordance with the term, either the buyer or seller is unwilling to execute the release of deposit, the buyer and seller hereby acknowledge and agree that the broker may distribute the deposit in accordance with the provisions of section 17505B of the Business and Occupations Professions article. Now, what does that mean? Well, some of you have maybe heard about those 30-day letters that brokers are able to write in order to sort of clear the deposit. That's what the statute's referring to in that particular case, because really and truly, when I think about an earnest money deposit, there's really only three ways to deal with it. It either gets dispersed at settlement as part of the settlement funds. The parties execute a release of deposit agreement, or you need a court order. Now, there is this other option if your broker is holding the funds, which is basically this 30-day letter. But there are certain times when that's a good idea and certain times when it's not. Because if you have a contested deposit issue, and you're telling your broker, hey, just, let's send that let's send that, 30-day letter and, let's clear this up. That may not necessarily be the right move in that particular case. Okay. So, if there's any discussion about what the issue is with the deposit, I'm going to encourage you as agents to work it out with your clients and with the opposing party, because oftentimes, if earnest money deposits, a lot of the earnest money deposits I see are, between say $1,000 and $10,000. $10,000, maybe you're starting to talk about some real money, but if you're talking about, a $2,500 deposit or $1,000 deposit, I certainly recognize that, for your client, that could represent a lot of money. But in the grand scale of a real estate transaction, sometimes it's best to sort of see what deal can be struck. But the other part of that, in terms of protecting your client's deposit, sometimes depends on why the contract fails. Okay. So those are all things to consider. The other thing that I just want to mention here, because this seems to come up quite a bit, when you use the Maryland Realtors contract, okay, there is a unilateral notice of termination, and then there is also the earnest money deposit release form. Okay. So the situation is this: if for some reason there is a unilateral notice of termination, that is okay. That does not need to be countersigned by the other party. And maybe you're releasing because your loan fell through. Maybe on the seller side, you're releasing because the settlement date has come and gone and you're just kind of done with this whole mess. And that's fine. For whatever reason, maybe the home inspection is a problem, whatever the case may be. Okay, we have our unilateral notice of termination. However, keep in mind that unilateral notice of termination is just one step of a two-step process, because you still have your earnest money deposit to deal with. Your earnest money deposit requires the earnest money deposit release form, because that's the form that Realty Title Services or Fairfax Realty is going to use to determine how to return the money. Okay, because it is not always a given that the buyer is going to get their deposit back. Perhaps there's some issue that entitles the seller to some funds. Maybe people are arguing about this, that, or the other thing. And so we need, in order for our compliance issues as your title company and your brokerage, we need to have that form signed. Okay. So if you are using the unilateral notice of termination to terminate a contract, just understand that does not do anything to the earnest money deposit. That merely terminates your contract. You have to have, it is a two-step process, okay? So you must have that other form. So that is all I have to say about deposits. And also I will just say, just like last time when we did this, if you do have questions or what have you, I just encourage you to put those questions in the chat box, and I will get to those if I can figure out how to. There we go. Here we go. And I will get to those periodically. Okay, so that's how we will do those. Assuming I can find all those. So that is paragraph 20. So paragraph 21 is deed and title. So what this is telling you, whoops, we went a little too far. What this is telling you is that upon paying the purchase price, the deed for the property will be a special warranty deed and further assurances, except in the case of a transfer by a personal representative, and the seller shall convey title, including all chattels. Out of curiosity, do we know what chattels are? So I will tell you, it is, chattels are personal property. So it's the pool cover, it's the bookcases that someone left behind. It might be a big screen TV. Those are the chattels. Okay. So what they're saying here is that the seller needs to convey the property, including all chattels, to have good merchantable, be free of liens, except as specified here, and except for use and occupancy restrictions of public record. And that the buyer is expressly and assuming all risks of the restrictive covenant, zoning, etc. Okay, so this is where your title company is really coming into play. Okay, because in the background, what we're doing when we are preparing for settlement is we are ordering the title search. We are discovering what liens are on the property. Maybe it's solar panel financing statements. Maybe someone repaired some siding or got new windows and they're paying on time, and so there's a financing statement for those fixtures. Maybe there's, mortgages, etc. Whatever liens may be on the property. That's what we're doing to clear liens, and so that way we can give your buyers good merchantable title. Okay, but sometimes, as you know, things happen. Okay, and so this is the paragraph that we come to, and it says right here, I just had it, here we go. In the event seller is unable to, here we go, give good and merchantable title as can be insured by a Maryland licensed title insurer, with the buyer not paying more than the standard rate, seller at seller's expense shall have the option of curing any defect so as to enable seller to give good merchantable title. Or if buyer is willing to accept title without said defect being cured, paying any special premium on behalf of the buyer to obtain title insurance on the property to the benefit of the buyer. So this is sort of interesting because some of you have run into me with situations where I said, well, we don't necessarily have a legal issue, but we do have an insurance issue. I've had this fairly recently with regards to, this was a DC case. And for those of you who work in DC, you know that TOPA, which is the Tenant Opportunity Purchase Act, is the bane of our industry. And there was a case where there was a family member that was staying in the house, and there had been litigation surrounding this particular person, and they weren't really a tenant, but there were some other problems. And so I went to our underwriters at First American, and we kind of went back and forth, and they said, well, we agree with you, there's no problem with the legal transfer, but we have an insurance problem based on our claims experience. So I said, okay. So I had to deliver the bad news to our parties that unfortunately, although title, the title couldn't be insured as a result of this particular issue. And sometimes we run into these issues with I've seen in Baltimore, like if there's building violation notices and condemnation notices and things like that. And so this is typically where you might hear me talk about, well, we can write an exception into the policy, or, we can do things like that in order to help clear title to ensure the transaction. But the thing to remember is that if you have a lender involved, lenders don't typically allow exceptions for things like this. If it's a cash transaction, that's a different story, because then you might hear me talk about, well, let me talk to the buyer and let's see what's going on here to see if, let's see what's going on here to see if the seller is, or the buyer is willing to take the risk. Okay. But we have fewer options when it comes to insurability when we deal with lenders, when lenders are involved. And so, but this is the part of the contract that talks about how the seller needs to convey title, and then it must be good, merchantable, such that it can be insured. Okay. And then it also explains that if the seller is unable to cure title defects and is unable to obtain, and we are unable to obtain a policy of title insurance on the property for the benefit of the buyer from a Maryland licensed title insurer, the buyer shall have the option of taking the title that seller can give or terminating the contract and being reimbursed by the seller for the cost of searching title as may have been incurred not to exceed 0.5% of the purchase price. In any event, there should be no further liability or obligation on behalf of the parties, and the contract becomes null and void, and the deposit is dispersed in accordance with the deposit paragraph of this contract. Okay. In no event shall the brokers or their agents have any liability for any defect in a seller's title. So this is the bread and butter, and this is why you come to Realty Title Services, because we are being asked to insure the transaction. And like I said, when there is a lender involved, sometimes insurance can be a little trickier than if there's cash. So, but this is the paragraph that explains how title will be transferred and what type of title there will be. And the only other thing that I'm going to talk about is, in the beginning, we talked about obtaining special warranty. So, and what special warranty title basically means is that the seller hasn't done anything to their title. And so there's other types of title, because many of you might be familiar with quitclaim deeds, which have no warranties of title. And for those of you who do business in Virginia, they typically do general warranty deeds, and general warranty deeds provide greater protections, but they are not the standard in Maryland or DC. Special warranty deeds are what we do in Maryland and DC. Okay. So we've done deeds. So now we'll talk about condition of property and possession. So at settlement, the seller shall deliver possession of the property and shall deliver the property vacant, clear of trash, debris, broom clean, in substantially the same condition as it existed on the date of the contract acceptance. Buyer reserves the right to inspect the property within 5 days prior to settlement, except as otherwise specified in the contract. Including this paragraph, the property is sold as is. The obligations of the seller provided in this paragraph shall be in addition to any disclosure or disclaimer statement. And we talked about the disclosure disclaimer statement. So here's what I want to tell you about condition of property. This often happens. When you first go see a property, the seller is still living there. They have bookcases, they have furniture and stuff and things. And of course, we're respectful. We're not necessarily going out to move bookcases. And then maybe we've hired a home inspector to go see whatever's going on. Suddenly, guess what? We are now on the day of settlement, a couple days before settlement. We're doing our final walkthrough. The seller has cleared out because they're moving. And suddenly I get a phone call that says, well, we couldn't see that there was mold on this wall or that X thing wasn't working because it was behind a bookcase, there was a chair, whatever the case may be. What do we do? Well, I'm going to tell you a strict interpretation of this paragraph is basically, well, you had the opportunity to inspect the property. If that condition was there on the date the contract was signed, then I guess you're out of luck. Okay. What often happens in these cases, as you may know, is sometimes there's a little horse trading back and forth with the buyer and the seller, and sometimes it's a real problem. So I just want you to understand that, you know, when a property is being sold as is, that's exactly what it means, especially if you've had the option to do a property inspection. You know, if there's something that you couldn't see because there was a piece of furniture there, I certainly understand the frustration, but by the same token, we're all agreeing that the property is as is. And if everybody has a right to, you know, inspect the property, you know, maybe you need to peek behind that bookcase, or if there was a big chair there, maybe try to just peek behind, shine a flashlight, whatever the case may be, just to make sure that there's no indication of something bad going on behind a large piece of furniture. But that is as is. So adjustments, paragraph 23. So this is ground rent. Homeowners associations fees, water, rent shall be adjusted and apportioned as of the date of settlement, including taxes. So here's what's going on here. You're familiar on the settlement statement with the prorations portion of the settlement statement. This is the paragraph that's telling you about the prorations, okay? And keep in mind, so if you are selling property in Montgomery County and Prince George's County in DC, we can get final water bills for those counties. There are some places we do not get final water bills. City of Baltimore, County of Baltimore, because Baltimore City Water is dealing with it. Anne Arundel County. Those are the ones that come to mind off the top of my head. All of those places do not provide final water bills. And so all of those places you may find prorations. And sometimes just, and one of the issues with the prorations that sometimes come up has to do with time of usage. So we try very hard to make sure that, because, you know, your bill dates and your dates of usage are sometimes different with water, and we try very hard to get it right, which is why sometimes we do a proration, plus we keep some escrow in those jurisdictions, because sometimes the proration is just not enough. And so as an agent, you know, you should just be hopefully helping your client understand how these adjustments work and why we're doing them. But the one thing I do also want to bring up is this whole heating fuels or cooking fuels that may remain in the supply tank at time of settlement becomes property of the buyer. So here's the one that comes to mind the most. If you are selling a home that has an oil tank, okay? If your seller just filled up the oil tank because they wanted to be nice to the buyer, make sure that the title company knows that we need to prorate that, okay? Because that's information that is not readily available to us. Again, also, maybe you are somewhere where maybe someone's got propane tanks, and they're using propane for, you know, heating fuel or heating or cooking or whatever. Again, you know, if the seller wants that stuff prorated, you have to tell the title company or we're not going to know. So that's adjustments. The next one is settlement costs. And this comes up quite a bit. So here's the situation. Paragraph 24. The buyer agrees to pay all settlement costs and charges, including but not limited to all lender fees in connection herewith, all title examination insurance fees, loan insurance premiums, document preparation, recording fees, notary fees, survey fees were required, all recording charges, except those incident to clearing existing encumbrances or title defects. And then this talks about if a buyer is a veteran obtaining VA financing, there are certain charges that are prohibited by the VA. And the seller may be subject to additional charges from the settlement company to cover reasonable additional costs of accommodating a seller's request. In such event, a seller is advised to contact the title company to determine what charges may apply. So what this means is, if you notice on the affiliated business disclosure that we provide and that you should be using in your contracts, it lists out all the fees that we will charge a buyer and a seller. Now, you should understand that theoretically, if the buyer is agreeing to pay all settlement costs except for items specifically related to removing encumbrances on the seller's property, well, guess what? That means the buyer pays everything. But we recognize that this paragraph exists in the MAR contract. So we don't typically charge your clients extra. We just, make adjustments as necessary on the seller side, because certainly we want everyone to have a successful transaction. But if you are concerned about any charges that you think, sellers should be paying for, I do have an addendum that I have given out from time to time that addresses this particular paragraph. And basically what that addendum says is that buyer and seller will split their cost of settlement. And this is one place, although we have not talked about GCAR, I'm going to talk about it for a second, because this is one place where the GCAR contract and the MAR contract differ. The Maryland Realtors contract has you pay all costs. The GCAR contract is very specific that the buyers and sellers pay separate, and it obligates the seller to pay settlement costs. Okay. And so by making sure that you're dealing with your seller, you could be protecting your buyer's costs in the transaction to make sure that they are paying only what they are supposed to. Next paragraph. Chapter. It feels like a chapter, doesn't it? Transfer taxes. Okay. So here's the situation. And this paragraph changed, I think, last summer. Okay. Particularly where it applies to first-time home buyers. But here's the situation. So transfer and recordation taxes are shared equally between buyer and seller, except if your buyer is a first-time home buyer. Under the statute, if your buyer is a first-time home buyer, the seller actually pays all transfer and recordation costs, unless there is an express agreement to do otherwise. Now, for those of you who have been practicing for a long time, you know that there's that first-time home buyer addendum. And usually you fill that out and everybody agrees that everyone's going to be 50-50, right? Well, guess what? You don't have to do that anymore. The reason is because here in bold, this bold language that's right here that talks about recordation and local transfer tax. This is doing your split for you. Okay, because it says, if the buyer is a first-time Maryland home buyer, buyer and seller expressly agree in accordance with the statute that payment of recordation and local transfer tax shall be shared equally between buyer and seller, unless a first-time home buyer transfer and recordation tax addendum is attached, which contains a different express agreement. So if all you're going to do is split the taxes 50-50, you do not need that other addendum. If the seller is going to pay everything, as what the statute would do, then you do need the addendum. So just keep that in mind. Okay, so that is what, so that's what's going on there. So I'm going to stop the sharing, or let's do broker liability, and then we're going to stop the sharing so I can check the chat box, because for whatever reason I can't see it quite yet. and we'll go and take a look at and see what's going on. So, chapter 26, broker liability. We went a little too far. But what this says, and you should really like this, is brokers and their agents, subagents, employees do not assume any responsibility for the condition of the property or the performance of the contract by any parties hereto. By signing this contract, buyer and seller acknowledge they have not relied on any representations made by brokers or agents, subagents, or employees except those expressly set forth in this contract. So as agents, this is you telling everybody, don't blame me for the condition of the property. I'm telling you, go get a home inspection. Okay. You cannot rely, basically what this says is you cannot rely on anything I say. Now, we all know the truth of the matter, that's not necessarily true, but guess what? We're being upfront and we're saying that we are not liable for the condition of the property, and that your clients are not relying on anything you've said about the property. Okay. So let me stop sharing for just a second here and see if there's anything in the chat. Anybody have any questions? Nope, no questions in the chat. Perfect. Then we will go back. I'll share the screen again. And we will move on to broker's fees. Okay. Now, this is very important, okay, because y'all want to get paid. I like to get paid too. Oh, here's where it is. All right, cool. It just showed up. All right. All parties irrevocably instruct the settlement officer to collect a fee or compensation and disperse the same according to the terms provided in the listing agreement and or agency representation agreement. Settlement shall not be a condition precedent to a payment of compensation. What does that mean? It means that you can get paid according to your listing agreement and your buyer agency agreement. Now, this whole business about settlement not being a condition precedent. There are circumstances that may arise from your listing agreement or your buyer broker agreement that may allow you to get paid if settlement does not occur or is delayed or some issue. I'm not going to go too far afield on that other than to say if there's a protection clause in your agreement or something about, bringing people, bringing good faith buyers and things expire, what have you. All of that is for a different class, different day. Okay. So paragraph 28, seller responsibilities. And the seller does have some responsibilities. The seller is going to agree to keep the existing mortgages free of default until settlement. So just because you're selling doesn't mean that you can't stop paying your mortgage. Okay. Don't tell your clients to do that. Tell them to pay. They are responsible for all violation notices or requirements. And they have to comply with everything. The property is held at the risk of the seller until legal title has passed. Now we have to say that, and that's important. And what that means is make sure that your seller doesn't cancel their insurance on the house because they're still responsible. And the reason why we have to say this is because under the common law, it's actually the buyer who's responsible. And so our contract is making sure that we all understand until legal title is passed, and that is when we come to settlement and everybody signs and we've got all the money. That is when legal title is passing. Okay. Or possession has been to the buyer. And or possession, I think, is also important because if you have a pre-occupancy agreement, at that point, it could be the buyer's obligation on the property. Okay. So if the property is destroyed or damaged without fault of the buyer, then the contract at the option of the buyer shall be null and void. So if something happens to that house and there's no house to buy, the buyer can get out of the contract. Okay. Whoops. Ooh, this is really going a little bonkers. Let's see. So buyer responsibilities. Buyer has some responsibilities, but let's see, someone entered something in the chat. If my client wants to choose a different title company, does she or she still have to sign the affiliated disclosure? That is a good question. And my answer is yes, for compliance issues. Because if your client is using a company that's not Realty Title Services, first of all, we hope you'll give us a fair shake. But even if they're not, because we are affiliated, it is just good practice to have that paperwork in all of your transactions. So that way you're not having to remember what's good and what's not. And your brokers at Fairfax Realty are going to ask for it every time, regardless of who the title company is. So you should always use your affiliated business disclosure in all of your transactions. Good question. Okay. Buyer responsibility, paragraph 29. If the buyer misrepresents their ability to consummate the purchase of the property, or the contract is contingent upon the buyer securing a written commitment for finance and buyer fails to apply for the financing, and fails to pursue financing diligently and in good faith, or the buyer makes any misrepresentations in the document relating to financing, which causes the buyer's disqualification, the buyer shall be in default. And the seller may elect written notice to buyer to terminate the contract or pursue remedies set forth in the default paragraph. Basically, the buyer can't lie about their financial position, okay? And if they do, that could be grounds for the seller to terminate the contract and defaulting. The HOA paragraph, I don't think we need to talk too much about that. Because basically what you're stating here is that you're not in an HOA unless you attach the addendum. So ground rent. So here is what I'm going to tell you. This is just in here on page 1 of the MAR contract. It actually asks you, and I know we talked a little bit about ground rent last time, and I'm talking about paragraph 5. All right. Whether you are electing, whether you are getting the property as ground rent or as fee simple. The story, this paragraph is addressing ground rent. And it needs to be, if it's not timely paid, if there's a ground leaseholder, can bring an action. Some things here have changed over time. But basically, if the property is subject to ground rent, upon obtaining ownership of the property with certain rights, it is subject to the ground rent. Okay. Basically, the story is typically, as the title company, we're able to tell you if there's ground rent, but you should also be able to, you should also know ground rent. Typically, we see it in Baltimore City, Baltimore County, and I see some in Anne Arundel from time to time, particularly in Glen Burnie. So what I would tell you is that, if your property is ground rent, if you ever look at Maryland land records, if you ever see a deed that says deed of assignment, you have ground rent. When a deed says this deed, it's typically fee simple. And you can, a buyer or a seller can redeem ground rent at any time. If you don't know who the leaseholder is for the ground rent, there are ways to deal with that as well, but that is a whole other class. So we'll just leave that there and move on to paragraph 32, which is the sale or settlement or lease of other real estate. And what this says is neither this contract nor the granting of buyer's loan referred herein is conditioned or contingent on the sale or lease of a different real estate unless you have an addendum. Okay, so if your buyer needs to sell another house first and you want to make sure you don't default on your contract, make sure you use the appropriate addendum. Leases. The seller may not negotiate new leases for the existing property or that extend beyond the settlement or possession date. This is typically in a landlord-tenant situation where you've got an investor who's selling. The seller can't negotiate a new lease because he's selling the property. Seems pretty normal. Paragraph 34. default. So for those of you who come to me and say, something happened with my contract, someone's in default, this is where I come back every time to figure out what's going on. Because this is the paragraph that talks about what happens to the earnest money deposit in default. Okay. And so we start out here. If the buyer fails to make full settlement or is in default due to the buyer's failure to comply with the terms and conditions of the contract, the initial deposit and any additional deposits may be retained by the seller as long as a release of deposit agreement is signed and executed by all parties, expressing that the deposit is to be retained by the seller. If the parties do not agree to execute the release of deposit agreement, buyer and seller shall have all legal and equitable remedies. That means going to court. So if the seller fails to make full settlement or is in default due to the seller's failure to comply with the terms and conditions, the buyer is also entitled to pursue any remedies available at law, including and without limitation to an action for specific performance. Specific performance, if you'll recall, is forcing the sale through court action, and monetary damages. In the event of any litigation or dispute between the buyer and seller concerning the release of the deposit, the broker's sole responsibility may be met at the broker's option by paying the deposit into the court where the litigation is pending, or by paying the deposit into the court of proper jurisdiction by an action of interpleader. Buyer seller agree that the broker's payment of the deposit to the court, neither the buyer or seller shall have any further right, claim, or demand against the broker for the release of the deposit, and they will jointly and severally indemnify and hold the broker harmless from all rights and claims. In addition, you will also be paying the broker's court costs to deal with all of this. So, and I'm going to talk about a little bit difference here. So in default, okay, oftentimes in our normal practice, you know, if the seller keeps the earnest money deposit, we typically sort of view that as liquidated damages, and that's the end of the story. But it's not the end of the story here, because this default paragraph does not limit the seller to only collecting liquidated damages. Basically, either the buyer or the seller, if they're not unable to come to some agreement on the earnest money deposit or whatever the damages may be as a result of default, if they can't come to some agreement, then everybody's going to court. And that's essentially what this paragraph says. And then it also says that if we can't decide what we're doing with the earnest money deposit, then the broker who doesn't want any liability for this deposit anymore is welcome to put the money into the court. Now that requires court orders and a whole bunch of other stuff, but that's certainly an option. And I am going to just highlight here for a minute, although we haven't gotten to GCAR, that this is a difference with the GCAR contract, because the GCAR contract actually talks about liquidated damages, and that damages can be capped by the amount of the earnest money deposit. So, I mean, I typically see our practice in Maryland that, you know, the earnest money deposit is basically our damage, but that does not have to be under this paragraph. So, so it is in everybody's interest to avoid court and, you know, make a deal that is going to work for everybody. Because what I will tell you is that litigation on principle is expensive, and it doesn't always get you where you want to go. And it's time consuming. And did I mention expensive? So let's see. We have a few questions. Let's see. So a follow-up question from Fatma regarding the affiliated disclosure. Yes, the seller should sign it too. Just because, you know, just make it part of your contract presentation so it's in there. Regardless of which title company you choose to use, that way it meets all of our auditing standards. And Juan Flores is asking, so a lender denial letter is not enough to protect the buyer's EMD. So my answer to that is it depends. So if the denial is through no fault of the buyer, okay, the buyer doesn't qualify, there's a problem with the appraisal, so the lender won't lend, or maybe, the buyer has tried to get some document that the lender wants, but the buyer just can't get it, they don't have access to records or whatever the case may be. That is enough to protect the buyer's EMD. What is not enough is, sometimes, because sometimes, buyers get cold feet, maybe there's another house they want to have, and so you're trying to rely on your financing contingency to get rid of one contract so you can move on to maybe the next property of your buyer's dreams. So I'm going to be careful. I'm going to tell you, because I've seen this happen where they go ahead and get a denial letter so that way they can get out of one contract so they can move into the next contract. I'm going to tell you that, according to the terms of the contract, having that denial, okay, that certainly satisfies your financing contingency because the lender won't lend. But if the buyer has something to do with that, then it's possible, if the buyer has something to do with their own denial, either by not following lender instructions or whatever the case may be, then it's possible the EMD could be at risk. Now, what I'm going to tell you is, in reality, it could be hard for a seller to figure out why a lender is denying financing. So I'll just leave that there. But I hope that answers your question. Okay. So we've talked about default. So now we are going to move on to mediation. Chapter. I keep saying chapter. I don't know why that is tonight. 35, paragraph 35. So, mediation. So if you are having a problem with your contract, with your buyers and sellers, mediation can be done. And to resolve a dispute or a claim with the assistance of a neutral mediator. So if either party elects to have an attorney present, they can. Mediation is done through Maryland Realtors or its local boards of association in accordance with established mediation rules. And so basically what I'm going to tell you, the buyer and seller are agreeing that the dispute or claim arising out of this contract or the transaction, which is the subject of the contract, can be mediated. And so it says, unless otherwise agreed in writing, the parties will, the cost will be divided equally between the parties. And mediation might be a good idea. So before you go to court, the buyer and seller further agree that the obligation of buyer and seller to mediate, as herein provided, shall apply to all disputes or claims arising whether prior to, during, or within 1 year following the actual contract settlement, or when settlement should have occurred. They agree that neither party shall commence any action in court regarding the dispute or claim arising out of this contract without first trying mediation. So basically, if you're having a problem, your first stop is not necessarily at the courthouse steps. It might be to do mediation. I will tell you, I've been a participant in mediation, both as an attorney and as a principal in the matter. Sometimes it works, sometimes it doesn't. If you want my full thoughts on that, just let me know. But I do think it can be valuable, and it can also help your clients understand their positions a little bit better and maybe help them back off some principle, because sometimes clients are just so caught up in the matter that mediation might be able to give everybody some space to assess where they are. Okay, paragraph 36. Attorney's fees. In any action between the buyer and seller based on the performance of this contract, the prevailing party can ask for attorney's fees. In addition, buyers or brokers that are made a party to an action, there's going to be attorney's fees in the event that there is success. So just keep in mind that what this paragraph basically does is it gives your clients the options, should they move into mediation, court, etc., that they can also sue to recover reasonable attorney's fees. And it also allows brokers to do that as well. And attorney's fees, in terms of how the brokerages work, are also addressed, my recollection, in the listing and buyer broker agreement. Paragraph 37, notice of buyer's right to select settlement service providers. The buyer has the right to select the buyer's own title insurance company, title lawyer, settlement company, escrow, mortgage lender, or financial institution. Seller may not be prohibited from offering owner financing, as buyer acknowledges that seller may not be prohibited from offering owner financing as a condition of settlement. So here's the deal. Many of you ask, or you see it in the listings, such title company is preferred. And I hear a lot that, well, John G, we'd love to settle with you, but the seller insisted that we settle with their settlement company. Well, here it is, folks. Paragraph 37. It is the buyer's absolute right to choose the title company. And the reason is because it is the buyer who is buying the insurance. And guess what title companies sell? We sell insurance. So even if there is a preferred title company of the seller, it is still the buyer's absolute right. So I understand that gets a little bit murky in practice, but make no mistake, the statute is on your side, the contract is on your side. It is the buyer's right to choose the title company, period. Okay. Property owner's title insurance. Buyer at buyer's expense may purchase owner's title insurance at either standard or enhanced coverage rates. The coverage afforded by such title insurance would be governed by the terms and conditions thereof. Nothing is obligating a buyer to obtain an owner's title insurance policy at any time. All true. Coverage is subject to underwriting criteria of the title insurer. All true. Title insurance is optional, but here's what I'm going to tell you. Although it may be optional, it's one of those things that may help your client sleep better at night, especially if TOPA was involved in your particular transaction, especially if there's a short sale, estates, things like that. Because make no mistake, as the title company, we are certainly doing our due diligence to ensure that we uncover everything that we can uncover. But we're also human, and we also rely on third parties, such as we don't do our own title searches. We have companies that do them for us, okay? I have one case that we've been working on where it appeared there was an unrecorded deed and there was an unrecorded mortgage. Well, guess what? We finally found the mortgage, but it was misindexed. The last name only had 2 L's, but it was indexed with 3. We didn't find that. It took some time. But so these are the things that can come up. And so despite our best efforts, mistakes do and can get made. And one of the best ways to protect your client's investment, and this is oftentimes the largest investment that they will make, is by offering title insurance, is by the purchase of an owner's title policy. And sometimes people tell me, hey, listen, the lender's getting title insurance. That's fine. That's all we need. But I'm here to tell you that may not be all that you need. And here's why. A lender's title policy only protects the lender, and it only protects your clients up to the loan amount. It does not protect their full investment. Okay. So the best way to help your client sleep at night is to encourage them to purchase an owner's title policy. We can talk about more about that some other time because there are enhanced and standard coverages. And so if cost is an issue, we can certainly try to work with you to get the correct coverage, or at least some coverage to fit the needs of our clients. Okay. And paragraph 39 is just talking about truth in lending and RESPA. and they're authorizing the lender and title company to be able to disclose copies of those statements. Not a whole lot to discuss here. Oh my goodness, it's already 7 o'clock. Where did the time go? We have a question here in the chat. Let's see, Jerry. How about when the lender is not performing accordingly? I'm guessing this is about with settlement companies. And I do hear this from time to time. And the problem is the reality of the business and what the statute requires sometimes are two different things. It's a little bit like when I say legal requirements and insurance requirements are sometimes a little bit different. So here's what I have to say about it. It is the buyer's absolute right. Now, there may be times when a lender says we are not doing business with this title company for whatever reason they have. And I have seen it where lenders want to be bullies about it and just say basically, either you settle where we tell you or we're not going to lend. So I'm going to tell you that that's not allowed. But the fact of the matter is when your buyer has found the home of their dream and they have found a lender that is willing to lend to them, oftentimes those decisions are going to get made in certain ways. So if a lender is not acting accordingly, depending on the situation, I might have some suggestions for you. But what I will say, and I know that sometimes, in terms of one of the things I hear often is that, well, gee, the lender gave me the lead, so I needed to use the title company that the lender likes. And while I certainly understand from a marketing and lead generation point of view that, that may be the reality of the situation, but the statute is on your side once again. And again, the buyer can choose whoever they want, regardless of what the lender says. But, I understand and I am sensitive that sometimes the reality does not live up to the statute. So it is now 7 o'clock. So I think we will hold it here for this evening. And so next time when we meet, we will pick it up at paragraph 40, which is the limited warranty. We will be able to, finish up the MAR contract next time, and perhaps we'll move into GCAR. So maybe we need to extend the series. But before we go, I will open it up. If anybody has any questions, I'm going to do the stop sharing now. But if anyone does have any questions that they want to just sort of chime in for a minute or put something else in the chat, that's fine. No? Okay. Well, in that case, if you want, you're always welcome to shoot me an email, give me a call at the office. We are conveniently located in the same office as Fairfax Realty Premier, so you can always come by and see us. But if you do have any questions, let me know, and I will look forward to picking up at paragraph 40 next time.
Thank you, John. Nice meeting you.
Thank you for your time.
Thank you,
Mark.
John.
Thank you.
Thank you, John.
Thanks, everybody.
All right.
Okay.
Have a good night.
Good night.
Good night.